In a courtroom where every word carries weight, a battle unfolds over alimony, contracts, and public policy. One motion seeks justice, the other defends a law. As arguments clash and statutes collide, the question remains, when love ends, does the promise still stand?
Failure to state a claim upon which relief can be granted. I've set forth in my motion the reasons for that. As the court is aware that marital dissolution agreements, especially granted on the grounds of irreconcilable differences, are contractually binding. And again, this is the term of transitional alimony. Transitional alimony is not modifiable unless specifically under the stated under the statute, and I've set forth in the body of my motion the language found in Tennessee Code Annotated 36-5-121 subsection G. And as a result, if Your Honor will look at the petition filed to terminate, the only allegations are basically, if we can say, buyer's remorse, alleging that circumstances at the time of the divorce, when it was granted back in 2020, would not have rose to the level of a granting of transitional alimony. But again, Your Honor, this was a divorce on the grounds of irreconcilable differences, and a marital dissolution agreement was adopted at the time. And again, the language contained in the petition does not meet the statutory mandate for a modification, for which we would ask that the petition be dismissed.
Your Honor, I would ask one, to start, I'd ask to take leave before we amend the petition. Although I believe that the underlying petition in and of itself, the marital dissolution agreement, violates policy. So I would take leave of the court in my petition, add in an additional fact.
In the courtroom silent tension, arguments clash over a simple truth. A contract once signed binds both hearts and hands. The petitioner stands firm, demanding change. But the law is clear: irreconcilable differences cannot be rewritten like emotions. This isn't just a plea. It's a battle against time and statute.
Party, I can add in that additional fact, as he does reside with his fiancee now, although I believe that we would argue certainly that, but I believe the underlying marital dissolution agreement, the portion of the alimony, I believe, violates public policy, as on the face of everything in that divorce. She was the economically disadvantaged spouse, and therefore I'm not sure how she is the one paying alimony when the court has jurisdiction to strike a provision of any contract that violates public policy.
So you're wanting to set aside the entire divorce, because that's the net effect of what you're asking to do, because it is a divorce that was granted on the grounds of irreconcilable differences. And because of that fact, if you're saying that the agreement violates public policy and therefore should not be enforced, then the entirety of the divorce decree would be invalid and would not be enforceable, and therefore they would be back in the stage of being married.
Well, I think, Your Honor,
just making you aware of the significance, as I see it,
yes,
of what it is that you're arguing as far as the public policy.
I understand that. I believe that the marital dissolution agreement at most have a severability clause where we could strike a portion of the marital dissolution agreement while
not
still...
when it's an irreconcilable differences divorce. The statute's very clear in a marital dissolution agreement on the grounds of irreconcilable differences. All issues, and I've had some personal experience with this.
Transitional alimony, once meant to support, now stands as a center of conflict. One side argues it's unjust, the other insists it's unchangeable. Between policy and personal pain, the judge listens, knowing every word could tip the scales of justice.
We agreed on the property division and submitted to the judge a divorce on the grounds of irreconcilable differences and let him decide the custody issue. Nobody raised that issue except the Court of Appeals, who said by statute you cannot have an issue that is not resolved by an agreement. And if you have an issue that is not in total agreement, then the divorce cannot be granted on that grounds. They vacated our divorce even though neither one of us wanted that. So I'm just telling you that's
Right.
I think that's pretty clear that the law has remained that way in the last 30 or 40 years since that a case took place. But I understand your argument, but I just am simply saying that significance of that argument may also be may contain ramifications that are not necessarily what either party wants.
I understand, Your Honor. But if I may just take leave of court, I'll amend my petition to factor in the statute provision of that, and then we can just set it for hearing and go from there, I believe.
Your Honor, if I could, I don't have an issue if counsel wants to amend his petition, but I do have an issue if we're proceeding on the grounds that are still alleged in there. Again, I think I have clearly put out in my motion the basis of the factors that are necessary. And again, as Your Honor said, I cited the grounds of irreconcilable differences is that each and every provision has to be agreed on by the parties for the court to grant that divorce. So if they're seeking...
When a marriage ends in agreement, the law seals that fate. But today, one motion challenges not just money, but morality itself. Can a deal of the past violate the very policy of fairness? The judge must decide if justice means keeping promises or breaking them.
Something from that standpoint, and none of that is alleged in the petition. And so this is a contractually binding agreement. Now, and again, as it states in the statute, an alimony recipient lives with a third party in which case a rebuttable presumption is raised. One, the third party is contributing to the support of the alimony recipient, and the third party or is receiving support from the alimony recipient. So again, that's not alleged in this petition. So again, if they want to, if Your Honor grants my motion to what I would request respectfully is Your Honor to grant my motion to dismiss the petition based on the fact that as it is right now, that it fails to state a claim upon which relief can be granted, but grant relief within a certain period of time, 15 days, for them to amend the petition to allege alternative grounds. But the grounds that are stated right now, again, there's not a basis of voidability against public policy. Again, it's a contractual matter. There's no constitutional issue raised in this case. Each party is free to contract in any way they want. And for a provision to be void against public policy, then they would, again, as Your Honor has said, if it is void, then the divorce is void. Their marital dissolution agreement is not granted. Their parenting plan is not granted, which then puts me back in a situation because I first filed the petition.
If a contract stands against public policy, is it truly binding or broken from birth? The courtroom holds its breath as the judge weighs every statute, every clause, every consequence. One wrong ruling, and an entire divorce could vanish like it never happened.
Policy, then it's a new petition on the divorce, on the custody matter, and we're not bound by res judicata. We can come back in and allege in the custody matter that this is a new case, and we don't have to prove a significant material change in circumstances. So it bleeds over into my case on what Your Honor does on this ruling.
You know, I knew when I woke up this morning that it was Monday, so.
Raining and Monday.
Yes.
All right. I'm going to grant the motion to dismiss based on the grounds that are set without prejudice to the petitioner to file a new, this is granting your motion based on the grounds that are alleged because there's no allegation that meets the statutory requirement, but I am doing so without prejudice to Mr. Daniels filing an amended petition to terminate.
The decision falls, motion to dismiss granted. Yet the door isn't closed, only paused. The law allows one more chance, one more filing, one more fight. In this courtroom, justice doesn't rest. It waits for the truth to return, stronger than before.